Remembering that we're going to conclude with a panel discussion, question and answer with our speakers, so thinking of your questions.
Are you going to go to the homecoming?
We'll have the opportunity to bring all the speakers up and put them on a panel.
Okay.
The next speaker is Alex Hallback. Alex, as I introduced earlier, is a lawyer with the Cutler Law Firm here in Sioux Falls, and he is going to speak on nonprofits in a paperless and tech-savvy world. So, Alex, take it away.
They tell me it's really nice outside, but we've been inside all day. So you take care, buddy. Yeah, bye, Tony. Thank you. Bye.
All right. Did everybody hear me okay? Try to hold that mic a little bit. My name is Alex Hallback, and I am going to be talking about really the tech-related side of both the proposed act, what the changes in the proposed act will do from a technology perspective for electronic notices, for a lot of different issues. And then I'm actually going to jump into talk about what I believe to be a very relevant and current topic for nonprofits to consider, which is a BYOD device policy. So I'm going to talk a little bit about the proposed act and the changes, and then I'm going to jump to a topic that, for people that are here, just a current topic that's tech related. So I wanted to start by telling everyone here that I actually, in addition to practicing law, in another life owned a small tech services company. So technology is something that I live and breathe every day, have for a long time, have a lot of interest in. And so I'm going to kind of speak on the legal side of it, but then I have some knowledge and some information to share too as it relates to actual implementation of tech policies. So let's go ahead and get started here. The clicker will work. All right, so as we've been talking about, the current Nonprofit Corporation Act is codified at 4722. Okay? The revised or proposed act that we're talking about here will be introduced in the legislative session in 16. And it's going to cause or create significant changes to the code as we're currently governed. Okay? The legislation is much more modern. It has provisions that talk more exclusively about what we should be aware of in the world of electronic notices, in the world of electronic records, and all sorts of things that are not addressed in the 65 Act. Okay, so these are some of the highlights that are governing or are more specifically related to technology. Okay. The new act will establishes a framework to allow the articles of incorporation to be filed electronically with the South Dakota Secretary of State. So for practicing attorneys out there, as you know, the articles of incorporation are still signed by 3 incorporators for a nonprofit, and then they're mailed to the Secretary of State. If they want the original signed version with the Secretary of State, they have to issue the articles. Okay. This new act will allow at least the framework for us to be able to file those articles electronically. So that's a good step. Some new definitions that you'll see in the proposed act that are not in the 65 Act. It actually defines electronic as being relating to technology having electrical, digital, magnetic, wireless, optical, electromagnetic, or other similar capabilities. Okay? There is no electronic definition right now in the existing code. Okay? We're also going to talk about records in terms of information that is inscribed in a tangible medium or that is stored in electronic or other medium and is retrievable in a procedural form. Okay? This is also going to be a deviation from the 65 Act in that a record now can be digital. Okay? You can have it saved on a server. You can have it saved on your computer. Whereas as we sit now, if someone comes in and they want to inspect the records, it's understood that you will have paper forms of all this for members to sit and page through. Okay? If it's required that it be kept, if it's a record that's required to be kept, it's required to be kept in paper. Okay? This changes that. Okay? The other thing is to sign. Okay? With present intent to adopt a record, to attach or logically associate with the record in electronic, sound, symbol, or process. Okay? This allows for the potential to do electronic signatures on documents or electronic, an intent to sign or to authenticate in an electronic format. So there's some pretty significant changes there just in the definition side. Okay, notice. You've heard a lot of people talk about notice. Okay? And what is required under the 65 Act is paper notice. Now, in the proposed act, notice by a corporation to a director, member, or a designated body or member shall be given to the mailing or electronic address of the person shown in the records of the corporation. If you have an email address for your members, now under the new act, you can email those notices out. You can, I suppose this would allow electronic address. So email notifications are huge. How many people email notices now to their board members? Show of hands. Hey, you can't do that. It's not allowed under the 65 Act. Okay? 1965, they didn't contemplate electronic messages, just like they didn't contemplate Skype or teleconferences or these big multi-conference chain conference calls. Okay? It wasn't thought of, so the Act doesn't address it. And considering we haven't done significant updates to that Act over the years, it's truly fallen behind. Okay? The proposed act further outlines that electronic communication is deemed received even if no individuals are aware of its receipt. Okay? So electronic communication is received under the new act when it enters an information processing system that the recipient has designated for use for the purpose of receiving electronic records or information of the type. Okay? This means when that, if I'm someone and I'm sending a notice to a member and it hits their email server, under the code it's deemed received. Okay? Doesn't mean that it has to hit your inbox. If it's filtered into spam, if it's for some reason doesn't get into your inbox, as long as it hit that server, it's going to be deemed received. Okay? So that's really important for you to know and for your IT professionals to know that it's critically important that those messages come through once you allow for this electronic notice and electronic communication. So definitely something to keep in mind. Okay, annual, regular, and special meetings. The proposed act states that the Articles of Incorporation or bylaws may allow for annual or regular meetings of the members do not need to be held at a geographic location if the meeting is held by means of the internet or other electronic communication technology in a fashion pursuant to which the members have the opportunity to read or hear the proceedings substantially concurrently with their occurrence. Vote on matters subject to the members or submitted to the members, post questions, and make comments. Now we can have annual meetings, special meetings, and regular meetings via Skype, okay, under the proposed act, or any other sort of online meeting place, GoToMeeting, whatever is most convenient, so long as members can actively participate, can ask questions, they can hear. This is a huge deviation from where we're currently at, right? Annual meeting, everybody gets together, everybody's bored, maybe 4 people show up, nobody really wants to be there, you don't really talk about anything relevant. Now you can do that via Skype, right? All right. So yeah, it's again a huge improvement from an electronic standpoint. Yeah.
Just as curious, so you asked us all to be already sent minutes and notices via email, but in regards to these meetings, say if we have 10 people or 5 of them are physically in the room right now, 1 of them joins via Skype, so that gives us 5 effective quorum.
Yep.
Any action under current regulation taken by that 5th person via Skype considered effective?
Right now, technically no. Right now, technically no. Okay. So that's why this is so important. Okay. It really brings, because I mean we've got nonprofits all over the city, nonprofits that I work with on a regular basis, even nonprofit boards that I serve on. That we have meetings. I call in. We We have members that call in, they vote, it's a quorum, but it's really, I mean, if someone wanted to push it and say, you technically didn't have quorum, the decisions you made technically weren't correct, they're right under the existing law, okay? So that's again why it's really important. If we can get this through the legislature in the way we want to here this year, it's really important that the organizations that you represent or serve make a conscious decision as to whether to fall under this new proposed act, what we'd like to call the 16 Act, or whether you're going to stay in 1965. Okay? So, good question. Books and records. Okay? The proposed act requires that nonprofits must keep minutes of all the meetings of the members, board of directors, and any designated body. A record of all action taken by the members, board of directors, or members of the designated body without a meeting, and a record of all actions taken by a committee of the board of directors or a designated body on behalf of the board. Again, the nice thing is here, though, that we can do this in electronic format. Okay, those records can be kept electronic, via PDF or Word or whatever works for you guys, but it can now be done electronically. Okay, it allows members to inspect and copy records, not just inspect. The 1965 Act allows members to inspect, but doesn't give them the right to copy. Okay, so this expands that a little bit and lets them have the right to take it if they want to, with 5 business days notice. So. The right of inspection may not be abolished. So you can't in your bylaws say members shall not have the ability or not have the right to inspect records of the board. Okay? It's not waivable. You can't get around that. Okay? And then this is another new addition that is really quite helpful. Those inspection rights that are given to members or board members or whomever, also it extends to their agents and attorneys. Okay? So now it's not, I as a member have to go into the organization, inspect and copy. I can send my attorney. I can send my accountant. I can send another agent operating on my behalf to go and do that for me. Okay? So a nice expansion. Again, the hope is that you're giving members access to the information that they need to ensure that the organization is being run appropriately. So we're trying to, with the proposed act, we're expanding that to make it easier. Okay? We're giving members more rights on this. Okay? Now what are we going to discuss? We're going to discuss Hillary Clinton. We're actually not going to, but... So everybody knows here, March, all the drama that kind of came with Hillary Clinton, right? Because she was operating, she was running state business through a personal email system, right? She had, IamHillaryClinton@gmail.com, and I'm going to conduct official state business on that email account, right? Well, now, what we're going to talk about today, the other side of my presentation, is really geared more at, okay, so what if I've got employees who are accessing company documents or company resources on a personal device, okay? So how many people in here have a personal cell phone, a smartphone or whatever? How many people receive work email on that personal cell phone? How many of you signed some sort of a document or an authorization that your company can wipe your device if you lose it, if it's stolen, if it's somehow compromised? How many people signed a policy or an authorization? We've got 1, 2, couple people, okay? So there are lots of issues that come along with what we call BYOD, okay? Bring your own device. Bring your own device to your company, okay? So some of the things we're going to cover today is what is bring your own device? What are some options for BYOD? Okay? Should you as a company or as an attorney recommend that that organizations you assist adopt a BYOD policy? What are some cost-benefit analysis that you can do to see if it's worthwhile for you to do that? Okay? Some technical possibilities, some options that might be out there on the IT side. What are some components of the BYOD policy, and then how do we actually implement it? Okay? First, what is BYOD? It's an IT policy in which employees are allowed or even encouraged to use their personal mobile devices, and that may be smartphone, tablets, laptops, desktops, watches, the smart watches might on the company network, all of that. Okay? To access employers' networking systems. Okay? So in that type of a situation, that personal device of yours, right, that personal cell phone becomes dual use. Okay? I'm going to call my friend and find out when we're meeting to go to the bar, and I'm going to be answering work emails at the same time. Okay? So it's now a dual-use device. Okay? Who pays for my device? Who buys the equipment? Who pays? Steve does. Yeah, Steve pays for my device. Who pays for the device? Who pays for the service? How does that all kind of factor in? And whose information is on here? Are the contacts mine or are they my employers? Are the emails mine or are they my employers? Okay? So lots of things to think about here. All right, some examples. IBM has 80,000 employees that currently use their own devices on their network. They hope to expand that to 440,000, 450,000 employees. Okay? They used to issue corporately owned BlackBerry devices. You guys remember those things with physical keyboards? They're not really around anymore. You know, maybe somebody has BlackBerry. Anyway, as iPhones began showing up in the environment, they made the decision to support the devices before their employees figured out how to support the devices themselves. Okay? So Kraft Foods, they started their BYOD in 2010. They provided employees with a stipend to purchase laptop or computers at the time. And if they decided to purchase a more expensive computer than what was allowed, then the employee covered the rest. Okay? Sybase, 4,000 employees, and they have BYOD. Okay? The tricky thing on this one is Sybase is actually a software manufacturer who makes the software that protects people in a BYOD environment. So of course they're doing it. But they have 4,000 people that do it. They allow their employees to choose between 20 different devices. Who even knew there were 20 devices to pick from, but there are. Phones. Employees purchase the phone, Sybase pays for the monthly service contract. Okay? But they must agree to allow Sybase to wipe the devices if they're lost or stolen. Okay? Critical thing that you need to think about in your policies. How do nonprofits different from some of those corporate partners that I just talked about? They don't. They're the exact same issues go across from the corporate world to the nonprofit world. The thing that's really important to take into consideration, though, and just like Bobby said earlier, resources are really important for nonprofits, right? They're watching their pennies, they're watching those dollars, making sure they're wisely spent. Well, the issues are exactly the same for nonprofits, but those resources to deal with some of those issues may be a little more finite, right? You have to really make a conscious decision as to what's going to happen in these kinds of environments. So, definitely something. Okay, what are some options for managing this device? Okay, there might be unlimited access for personal devices on an employer's network. There might be only access to non-sensitive systems and data. So maybe just you get access to like your office content list. Maybe that's sensitive, maybe it's not. Maybe you get access to the employee intranet that maybe has updates for what's going on at the office. We're going to shut down this wing, or this conference room is being in use, or something like that. Maybe you get access to that. Another option may be access to all of the systems and confidential information, but with IT control over those personal devices and the ability to store. Okay? And then the last is just access but limitations of storage. Okay? So we may allow you to access a PDF or something from your phone, but we're not going to allow you to store it. We're not going to allow you to save it. Okay? So there's maybe some limitations to view only. Big question. Well, I only have 2 or 3 employees. I mean, they're using their phones, but isn't that big of a deal? Do I really need to worry about a whole policy? Right? Do I really need to adopt a policy? Do I really need to include that policy in my employment manual? What am I really worried about? So the thing that I will tell you is just make sure that you're making a conscious decision on this. Okay? Run through the exercise of thinking through what issues may be out there, what concerns you may have with that confidential information, and make a decision that you can live with and understand the ramifications of doing that. Okay? The lines between work life and personal life have blurred significantly, and this continues to blur that boundary. Okay? I know that's the first thing I do in the morning when I wake up at 5 o'clock is I roll over and see who emailed me overnight. Right? I'm just weird like that. It's just my habit. But then again, that's technically if I'm an hourly employee, when I roll over and I'm checking email and I'm responding to work emails at 5 o'clock in the morning, am I in the clock? Okay, so there are wage and hour issues that you have to think about and need to make a conscious effort to address. Okay? So employees' conduct may dictate policy development as well. So how are people using Facebook, Twitter, LinkedIn, Snapchat, text messaging? Okay, I accidentally just Snapchatted or posted on LinkedIn a internal confidential document that was just emailed to me. Whoops, there it goes. So now all of a sudden the company is making the decision to limit access to Facebook, access to LinkedIn. Now that's all disabled, right? But it's a policy decision that companies need to make when they're thinking about the access to this information. And social media is a big thing and it's changing all the time. So, and then, do you know if your data is currently stored by employees? Do you have any idea if people are saving your forms, saving, from some of the big health systems here, HIPAA-related concerns? What's being saved? What's being stored? What's being accessed? So, it's better that you set the policies and procedures to support secure access to company resources and allowing your employees to establish practices and set those policies. Well, I've always been able to access Facebook. Why can't I access it now? Well, so make that conscious decision, okay? Think about what you want them to have access to and what you don't, and then set your policies around it. Okay? Some cost-benefit analysis, things to consider. Increased productivity. I can operate much more quickly on this device because I'm familiar with it than if you gave me an Android and said, here's a company-issued Android, you have to use it. Okay, I'm going to fumble around, I'm going to be slower on it, I'm not going to be able to get as much stuff done. Okay? So think about the increased productivity. How about employee satisfaction? Employees, have chosen the device that they're working on. It kind of prevents possibly the need for me to carry 2 or 3 cell phones, depending on what deal I'm working on. So there's cost savings to it, or can be cost savings to it. Okay? Sometimes a good, well-drafted BYOD policy will shift some of those costs to the employee if they're paying for the device and data plan. Okay? But be careful on this, because with technical security administrative costs, sometimes those cost savings can actually be quite minimal. Okay? If I have to hire a new IT person, if I've got to buy all this software to run on these devices, I've got to be able to manage and support all this, maybe the cost of getting all of that set up will outweigh the 2 or 3 devices that you may have on that system long term. Okay? So think about that. There are definitely some pluses and minuses here on the cost. And there's a 2014 article in CIO magazine that said that a good BYOD program could cost as much as 33% more than a well-managed wireless program, okay, than the company issue. But it all depends on how you do it, depends on those policies, it depends on a lot of things. There are a lot of variables there. So definitely, run through the exercise of talking through, what are some of those concerns, so you can make a decision that works best for you. Okay, some more potential risks and considerations. Some employees will not, they just won't invest their own money into the device. They're going to say, if you're requiring that email be set up on it, then you're going to pay for it. I'm not going to pay for, having a data plan that's maybe bigger than what I would normally have, or I'm not buying some fancy device because you're going to somehow require me to be able to access my email and that sort of thing. So that's one thing to potentially be out there, is employee sensitivity to the cost of shifting some of those costs over to them, right? SDCL 62.1 requires employers to reimburse employees for all necessary expenditures incurred by the employee in carrying out the employee's duties. Okay? This would likely result in the employer being responsible for charges if remote use is required or even encouraged. Okay? So the one thing you want to be careful of is that if you provide access, and it's provide access to those devices, you have to be careful not to mandate it. Okay? Once you mandate it and say you have to allow the email to be set up on your device, you have to be able to be, if I email, you've got 15 minutes to respond to me, then it becomes a required thing that the employees need to reimburse for and pay 100% of. Okay? IRS regulations on fringe benefits. If you reimburse the employee for the entire cost of the device and plan, it'll result in an overpayment to the employee, which has tax consequences. Okay? That's now a taxable benefit to them. If you're paying 100% of it, and they're using part of it for employee use. So something to be careful of. To be exempt from payroll taxes, the payments must be made pursuant to an accountable plan. So the expense must have a business connection, okay, incurred as part of a work responsibility. The employee must adequately account to the employer for the expenses within a reasonable period of time. The employee must return excess reimbursement within a reasonable time. If you go down that route, okay? So, actual expense method is another option, which employers should provide records showing expenses incurred for business use. And this method is really difficult with the flat rate plans, okay? So I pay $40 a month, so each month I'm going to go through and allocate how much of it was a business call and how much was a personal call, and then try to get reimbursed accordingly. No. It's better to just, have the accountable plan, right? Where every month I'm reimbursing $50 a month, and it's not the entirety of it, and I understand that you're going to use it 20 or 30% maybe towards business, and then have an actual plan as to why you're reimbursing the amount that you are. Okay? So, do you have the resources to properly and securely set up the network to administer the necessary policies? Will it cost more than just providing the device? Again, all of those same questions that are good to ask when you go through this. Okay? More potential risks and considerations. Protection of trade secrets and confidential information. Employees who leave are more often than not taking at least some data with